डिस्कस करते हैं। अब डायरेक्टली बैरेक्ट पे जाने से पहले मैं आपको एक जनरल आइडिया दे देता हूँ कि क्रिमिनल कॉन्स्पिरेसी होता क्या है। सो क्रिमिनल कॉन्स्पिरेसी, ठीक है, यहाँ डेफिनेशन लिखी हुई है। तो सिंपल वर्ड्स में मैं बताऊं कि क्रिमिनल कॉन्स्पिरेसी क्या होता है। जब दो या दो से ज्यादा लोग एग्रीमेंट करते हैं कि कुछ इलीगल करेंगे, षड्यंत्र रचने को बोलते हैं कॉन्स्पिरेसी। तो जब आप कुछ क्रिमिनल करने के लिए, कुछ क्रिमिनल एक्ट करने के लिए षड्यंत्र रचते हो, उसको बोलते हैं क्रिमिनल कॉन्स्पिरेसी, ठीक है। जैसे दो लोगों ने प्लान बनाया किसी को मारना है, किसी तीसरे को, क्रिमिनल कॉन्स्पिरेसी। दो लोगों ने सोचा रचते हो, उसको बोलते हैं क्रिमिनल उसको बोलते हैं क्रिमिनल उसको बोलते हैं क्रिमिनल उसको बोलते हैं क्रिमिनल उसको बोलते हैं
सो अभी 2 बजे के बाद हियरिंग स्टार्ट होगी।
होगी।
Hello everyone. Uh, you can tell your views. जो जितने भी लोग देख रहे हैं कि डिसीजन क्या रहने वाला है. अभी 15 मिनट है लाइव हियरिंग स्टार्ट होने में. दिस इज ट्रू. दिस इज ट्रू दैट रिड्यूस हो सकता है. चांसेस हैं बिकॉज यूनिवर्सिटीज़ ने भी रिकमेंडेशन दिया है. हाई कोर्ट्स, आई गेस 10 हाई कोर्ट्स थे और एक भी हाई कोर्ट ने अपोज नहीं करा. यूनिवर्सिटीज़ ने अपोज करा है. और half of the university supported it. बट कुछ ने कहा है कि कम होना चाहिए, कुछ ने कहा है कि देयर इज़ वन यूनिवर्सिटी जिसने कहा है कि 5 साल हो जाना चाहिए, 3 से 5 कर दो. वाओ, शुक्र है 7 साल नहीं बोला, एडीजी के बराबर ही हो जाता. लेट्स सी, लेट्स होप फॉर द बेस्ट. लेट्स होप फॉर द बेस्ट. और आज फाइनल डिसीजन आने के चांसेस हैं और एक दो हियरिंग और भी लग सकती है. जहाँ तक है, एक दो हियरिंग और भी लग सकती है. दिस इज ऑल्सो पॉसिबल. देखते हैं अभी हियरिंग कब स्टार्ट होती है. और कुछ टाइम में होने वाली है स्टार्ट. काफ़ी एक्टिव हो गए लोग जस्ट बिकॉज ऑफ दिस हियरिंग. और हाई कोर्ट्स का स्टैंड वही रहा है, सेम टू सेम. आपने लिखा है कि सुप्रीम कोर्ट माइट नॉट अल्टर इट्स ओन जजमेंट, देन व्हाई दे हैव allowed for oral hearing? This is the question. कुछ आइडियोलॉजीज और कुछ माइंडसेट अलग होगा ये जो करंट प्रेजेंट जजेस हैं, जस्टिस हैं. सो देयर माइट बी चांसेस कि रिमूव हो जाए, बट उसके चांसेस कम है, रिड्यूस होने के चांसेस ज़्यादा हैं. सो बट आर योर थॉट्स, क्या हो सकता है? I guess finally your students are just praying for this. And especially those students जिन्होंने जुडिशरी, आई नो सम पीपल जिन्होंने जुडिशरी का कोर्स लिया और 10 दिन बाद ही ये जजमेंट आ गया. नाउ दे कैन नॉट वेट फॉर 3 years to give the exam. Now they are practicing. So काफ़ी lot of things are there, and I know 3 people, 3 लोगों को जानता हूँ मैं जिन्होंने बार काउंसिल में, स्टेट बार काउंसिल में रजिस्ट्रेशन नहीं करवाया हुआ, एंड दे आर प्रिपेयरिंग फॉर लास्ट 4 years, 3 years. So let's see. Uh, and the thing is, reduce हो भी जाएगा. अगर reduce होता भी है, हेलो प्रियंका. सो अगर रिड्यूस होता भी है तो कितना, एट मैक्स 1 year, 1 year तो रहना चाहिए. एंड द मेन थिंग, जो जो मेन पॉइंट है या जो मेन रीज़न है इसका 3 year रूल का, दैट इज़ ओनली एडवोकेट्स ओनली, जो सीनियर एडवोकेट्स हैं. 10-15 साल से प्रैक्टिस कर रहे हैं, when they see young uh, young blood on the bench, तो I think they cannot digest it. So हाई कोर्ट का ओपिनियन भी uh, उसी को ध्यान में रख के है, जो एडवोकेट्स का मत है वो काफ़ी इन्फ्लुएंस होता है हाई कोर्ट का ओपिनियन भी बिकॉज ऑफ एडवोकेट्स. सो दैट इज़ अ रीज़न आई थिंक कि सभी हाई कोर्ट्स ने नो हाई कोर्ट हैज़ अपोज दिस, नॉट इवन अ सिंगल वन. इलाहाबाद हाई कोर्ट ने बोला है कि they don't do not have a proper opinion regarding this, and Supreme Court can decide what Supreme Court thinks is fit currently. Just 5 minutes more, and uh, 5 minutes more, and there will be live hearing just start हो जाएगी. God only knows what will be in the judgment. All the High Court have same opinion because mostly High Court judges come from bar only. True, absolutely true, because I guess 70% of the High Court judges are from the bar, are elevated from the bar only. प्रमोशन से काफ़ी कम ही हाई कोर्ट जजेस आते हैं. एंड तो माइंडसेट वही है कि, और ठीक है, the better option, better approach will be to make it 1.5 years or at max 2 years, because 3 साल जब हम सोचते हैं दैट लुक्स, 3 साल अपने आप में बहुत लंबा टाइम लगता है. नॉर्मल ग्रेजुएशन हो जाती है 3 साल में. एंड इफ और तैयारी करते करते 3 साल हो जाए इतना पता नहीं चलता. बट इफ समवन मेक्स अ रूल, अगर कोई रूल बना है, ऑनरेबल सुप्रीम कोर्ट रूल बना रहा है डैट इट इज़ मैंडेटरी टू वेट फॉर 3 years एंड यू हैव टू डू प्रैक्टिस, और तो वो मुश्किल होता है फिर. दैट बिकम्स रियली डिफिकल्ट. आप तैयारी करते रहोगे 3 साल पता भी नहीं चलेगा, बिकॉज नॉर्मली टेक्स एटलीस्ट 2 to 3 years. ठीक है, आपकी किस्मत अच्छी है, आप पहले साल में बन जाओगे. थोड़ा सा आपका लक भी है और हार्ड वर्क भी है, बट नॉर्मली फॉर 90% ऑफ द एस्पिरेंट्स इट टेक एटलीस्ट 2 to 3 years of the journey it takes. Yeah, there is no opportunity, right? uh, the I think that the most difficult task is to wait for someone. When you have to wait for your friend even for like half an hour, वो भी बहुत मुश्किल लगता है. So it is a wait of 3 years. That this is really a lot of time to wait for. काफ़ी लंबा टाइम है. Waiting is most anxious time. Yeah. There is that is I remember a theory or something, literature, in the English literature, that is waiting for Godot. Waiting for Godot. That every person is waiting for something or someone at every point of time. Someone is waiting for something. अभी भी लाइव हियरिंग स्टार्ट नहीं हुई है. So let's see. हाँ, लीगल फिलोसफर. Yeah, waiting for God, but the spit spell, the spelling is Godot. The T silent. It is a play actually, and the philosophy that it gives is good, really nice. That we can see in our day-to-day life that we are waiting for something every day, every uh, moment of time, every point of time we are waiting for something. That is all a different concept. but वो यहाँ apply नहीं होगा, but just I मेरे को याद आ गया तो मैंने बोला. If just suppose कि जो भी आप यहाँ लिख रहे हो that is going directly to the Supreme Court judges, what would you write then? If you know that whatever you are writing here would go to the Supreme Court judges who are deciding the 3-year rule today, what would you write then? Still, we are waiting for the hearing to get started. Let's see. अभी भी start नहीं हुई है hearing. Hearing is about to start in some minutes. So थोड़ा वेट कीजिए. Let's wait for 5 minutes. I guess 2:10 या 2:15 तक स्टार्ट हो जानी चाहिए hearing. I guess it has started. I guess so. Yeah, the hearing has started. Let's go to the live hearing. Just a minute. Judges are yet to come. शौर्य पाठक, if मोदी जी himself is taking interest in this matter, then तो अच्छी बात है. क्या पता मन की बात में इस बारे में बात हो जाए. So, some people have joined, around 20 people have joined. So, what are your opinions? किसी का कोई ओपिनियन क्या हो सकता है? विल दिस बी अ फाइनल? आज फाइनल हियरिंग हो सकती है या नेक्स्ट डेट लगेगी? Yeah, as per the suggestions of universities particularly, it might be reduced. The question is कितना? 1 year, 2 year, 1.5 year? As per the suggestion of one university, it should be extended to 5 years. अगर 7 साल बोला होता तो एडीजी के बराबर ही हो जाती फिर तो एक्सपीरियंस की रिक्वायरमेंट. इट्स ऑलरेडी 2:24 और अभी हियरिंग स्टार्ट नहीं हुई है. लेट्स सी कहाँ तक कब तक आ रहे हैं जजेस. आई गेस 2:30. Look, I think the issue is not regarding practice only. वो प्रैक्टिस के रिगार्डिंग इशू नहीं है, मतलब हाँ है, बट आई थिंक इनडायरेक्टली जो सीनियर एडवोकेट्स हैं बस, एंड हाई कोर्ट में भी लगभग 70-75% ऑफ द जजेस आर फ्रॉम बार ओनली. सो वहाँ से भी यही सजेशन आ रहा है कि नहीं, 3 year रूल इज शुड बी मैंडेटरी. सो they cannot see the young blood. They do not want to see the young blood on the bench. थोड़ा उनका ईगो हर्ट होता है. सिर्फ सो दे वुड नेवर वांट कि ट्रेनिंग पीरियड बढ़ जाए, 2 साल हो जाए, 1.5 साल हो जाए, उनको मैटर नहीं वो मतलब. और उन्हें ये भी पता है कि 3 साल अगर प्रैक्टिस के बोल दिए जाएंगे तो कौन आ रहा है प्रैक्टिस करने. प्रैक्टिस और तैयारी एक साथ कभी नहीं होती है फॉर मोस्ट ऑफ द पीपल. 95% ऑफ द पीपल दोनों चीज़ें एक साथ करना काइंड ऑफ इम्पॉसिबल है. सो द इशू इज़ नॉट रिगार्डिंग द प्रैक्टिस, इट्स अबाउट द ईगो ऑफ द सीनियर एडवोकेट्स. There should be no BA. There should be no BA, only LLB plus 3 year practice. नहीं, आई डोंट थिंक सो ये होने वाला है, बिकॉज वो तो फिर दैट इज़ ऑल टुगेदर अ डिफरेंट इशू. वो यूजीसी कर सकता है या मतलब हाई कोर्ट सुप्रीम कोर्ट के हाथ हाथ में नहीं होगी वो चीज़. एजुकेशन पॉलिसी होती है वो, तो उसके अकॉर्डिंग होता है वो डिसाइड कि LLB BA के बाद होगी या डायरेक्टली LLB कर सकते हैं. क्या हार में क्या जीत में, किंचित नहीं भयभीत में, संघर्ष पथ पर जो भी मिले यह भी सहयोगी सही. या ट्रू, अच्छी शायरी है. 2 बजे, 2 बजे का ही टाइम था. नाउ इट्स लेट, आधा घंटा लेट है अभी हियरिंग. आई थिंक सो. फॉलो अप नहीं कर रहा था मैं, बट आई थिंक सो अभी मैटर सबसे पहले यही सुना जाएगा. आई एम मैरिड एंड वन चाइल्ड टू डिफिकल्ट फॉर मी मैनेज practice. Remove this it. 4K video isn't possible. एक्चुअली क्या है कि जो सुप्रीम कोर्ट है वही प्रोवाइड नहीं कर रहा ना 4K, तो मैं यहाँ पर कैसे प्रोवाइड कर सकता हूँ, है ना। एक पिटीशन डाल देते हैं 4K वीडियो प्रोवाइड करने की। सुप्रीम कोर्ट की हियरिंग 4K में होनी चाहिए उससे। जस्ट अ मिनट।
Courts are saying from page 1 to 7. Now, very broadly, my lord, the High Courts are view that 3 years should remain. Very broadly, they're of the view. And then they are also, of course, saying that so far as, my lord, the specially abled candidates are concerned, there should be some, maybe not leeway in terms of 3 years, but accessibility, etc., can be given to them, better accessibility and so on. That is what the High Courts are saying. If I may very quickly take your lordship through what the High Courts are saying. Page 1, my lord, is the Allahabad High Court. Here, my lord, the Allahabad High Court's view is, in fact, it's on bold. I put it in bold, my lord, on page 1. The High Court is presently unable, my lord, where it says, High Court is presently unable to offer a definitive opinion. My lord, page 1 of this note, my lord. I am very sorry, my lord. It's at, there's an index and then, my lord, there's a suggestions made by various High Courts in a table. Right at the beginning of the note, my lord, the third page. It's page number 1, though. So, my lord, I'll only read, my lord, the highlighted portion. High Court is presently unable to offer a definitive opinion on the reducing or dispensing with condition of 3 years practice at the bar. High Court defers to wisdom of the Supreme Court on the... No, that is because, you know, they are saying that it's too early for us to come to a view.
Too early because
Yes,
we get to experience the difficulty.
it has just happened in 25, so therefore that's the view taken. Correct. That's saying. Now, my lord, Delhi on the other hand, which is the next page, my lord. Here, if your lordship would just see, I'm not reading the whole of it. There is a, my lord, para, which says para 6, page 3. So this is what the High Court's affidavit at para 6, page 3 says. Accordingly, the matter was placed before Rules Committee of High Court of Delhi, which considered the matter in detail. My lord, the next page. I'm having placed Allahabad now, the next is Chhattisgarh. Chhattisgarh is only saying eligibility condition should be uniform for all categories of candidates. That's number 2. Delhi, which is number 3, my lord, I am placing before your lordship para 6, page 3, which is in the middle of the second column. Accordingly, matter was placed before Rules Committee of High Court of Delhi, which considered the matter in detail. It was noted that 3 years practice had been reintroduced as per the judgment directions of the Honorable Supreme Court, via a judgment dated 20th May 25 and so and so. It was also noted that 3 years practice at the bar was a mandatory eligibility condition for becoming eligible to appear in examination of Civil Judge Junior Division, which had to be met by all the candidates. Committee was of the view that providing relaxation in the mandatory eligible condition to a particular class of persons may lead to disparity or discrimination to candidates. Similar claims will be put forward by other categories of candidates. It would be appropriate that uniformity in the mandatory eligibility condition may be maintained in order to avoid any disparity or discrimination. The aforesaid view of the Rules Committee was duly approved by the Chief Justice of the High Court of Delhi. Then, my lord, 4 is Guwahati. And Guwahati essentially is saying that 3 years should be kept and uniformity should be maintained. So I have just summarized that in one line. My lord, Jammu and Kashmir, my lord, which is number 5. If your lordship would turn over the page to page 4 of this note.
The High Court will say that we understand.
Yes, so your lordships have understood that.
Say that Supreme Court is wrong.
No, I am not saying that.
Very practical.
No, nobody, my lord. No, nobody is saying that, but
What does the university say?
so for that, with your lordship straight away come to page number 8.
Page number?
8 of this very note. Now here, my lord, there are various views taken by various people, so there's no uniformity here. Of course, they can say what they want. Now,
Dr. Faizan.
yes, I am coming to that. I'll say that.
Faizan, my lords, has come out with a very comprehensive suggestion of a probation for 1 year, my lords. As part of the Vicus's observations, and what also
It's not 3 years as is absolutely okay, but we are only on the modalities part.
let's
Come out with some.
of course, my lords,
Lord,
some
before I-
suggestions, my lords, we have for your lordships, my lords, possibly.
Before I say that, my lord, these high courts, in fact, had earlier also said 3 years. It's not that, my lord, for the first time the High Courts are saying 3 years. In fact, your Lordship's judgment is based on the views of the High Court of 3 years, not that it was based on any other empirical data. My lord, if we come to
No other view taken, excepting for the High Courts, and that also in a limited way, my lords.
I'm reading all of them.
The students, the graduates, the aspirants, not one of the stakeholders has been taken into consideration, my lords.
Now,
The NLUIs are generally against the 3-year rule.
Out of the 17 NLUs, the 14 are in against the 3 years rule, Your Lordships.
So any university also supporting the 3-year condition?
yes, some of them are supporting 3 years. Some are, in fact, even one has, in fact, said it should be 5 years. That your lordship will not take very seriously. But some are supporting 3 years. Many of them are saying 3 years with accessibility. Many are saying reduce it. Some are saying reduce it from 3 years to 2 years or 1.5 years. Some are saying that also. And my learned friend just mentioned, I should immediately place is serial number 4, which is Chanakya Law University through Dr. Faizan Mustafa. He says that you should not have any experience at all. And then, my lord, you should do away with the.
So that the training period for civil judge be increased to 2 years with 1 year training in judicial academy and 6 month attachment with district.
That is what he's saying.
6 month attachment chamber of a civil advocate. So they are giving a
Substituted views.
alternative option.
Correct. Now, for then, my lord.
Your Lordships, you get recruited, then after that you go for the 1 year training, intensive training. So
Now-
the same thing for the ladies, Your Lordship, especially because of their childbearing age, and there are many other factors.
Let the person make a complete yes.
See his suggestions because they are excellent suggestions.
So, my lord, serial number 4 is, since I'll mention it, no problem at all. Dr. Faizan Mustafa's suggestions are, my lord, in fact, they are set out that the summary of it is at the bottom of page 10. So, he's suggesting that there should be comprehensive data collection till the aforesaid data is collected and presented before this court. This court may kindly put the 3-year rule in abeyance as many law graduates who graduated till the academic expectation of being eligible to write judicial services session have legitimate 24-25 have legitimate expectation they should be. In fact, ideally, all law students admitted to a law course till 2025 are to be exempted from the 3-year rule, as they would not have joined law if the option of writing judicial services after graduation was not available to them. Sudden imposition of 3-year rule is neither just nor fair. But he's one of the few people who's saying it should be totally done away with. For instance, the next one, Christ Law College, is saying it should be continued. 3 years should be continued. Similarly, Dr. Babasaheb Ambedkar School of Law also says it should be continued. Similarly, Hidayatullah National Law University, Raipur said you can have some relaxation for specially able candidates, but don't do away with it totally.
Law University has said that it has effective candidates from marginalized and economically weaker sections, social and educationally backward communities as well as women candidates.
Right. Your lordships are reading which particular? I'll just open that one for it. Yes, correct. Right, absolutely. So, and then, my lord, there's also a suggestion by Ms. Jana Kothari, senior advocate, which is page 13 is the summary of that, where she's.
Frank Paul says 3-year practice is not required at all. 3-year, they say organizing, they are talking that again training module they are deciding. And then you done Patiala, Punjab also saying same thing. Aurangabad saying same thing.
What is the NLSI 3 years? 10 universities, my lord, say do away with it.
NLUs.
They are discussing right now. The lordships are discussing right now. तभी साइलेंस है, म्यूट हो रखा है. ऑडियो उधर की ही रखी हुई है, बट वहाँ से अभी ऑडियो रिसीव नहीं हो रही है. वही मैं बता रहा हूँ, दे आर डिस्कसिंग राइट नाउ. उन्होंने अभी म्यूट कर दिया है, सो दैट वी और द एडवोकेट्स कैन नॉट लिसन. And the only people who are supporting 3-year rules are those who are getting benefited from this rule. I think जिनकी 3 साल की प्रैक्टिस कंप्लीट हो गई है, अदरवाइज सब अपोज कर रहे हैं.
Millards, the whole issue, Millards, is not what we are envisioning, Millards, is the improvement of the system, Millards, the judicial and the justice delivery system. We don't want to put a roadblock, Millards, in their actual appointment or to take them away from the profession. Millards, we are encouraging everybody to go into the judiciary, Millards, to say it's a very good line to be in, Millards, and to go away from other practices also. Have this as an avenue. So then, Millards, to have a roadblock by putting in practice which is not even consistent with their roles as adjudicators, Millards. As adjudicators, the skills, Millards, subject to correction, Millards, would be honing some other skills in addition to the practice ones, Millards. So to have such a thing, Millards, is a roadblock A. Career progression itself, Millards, is put a roadblock to, because, Millards, what will be an average age will become of an aspirant to be about 29 years, Millards, once he graduates, another 3 years of practice, and thereafter, Millards, to go into the higher judiciary as an average ladder chart, Millards, is something about, I'm sorry, Millards?
29.
Millards, I say with 3 years practice, Millards.
23, 26.
Plus 23, Millards.
26.
That was plus 3, plus it takes couple of years for people to prepare, Millards. People don't prepare overnight.
The age is 24 plus now.
Let's take it exactly. So roughly about let's 28 to 29. I'll put it Millards another way. But it comes that that means Millards, with promotions to the high judiciary, Millards, it would come to about 41 Millards years of age.
6 years, a meritorious candidate.
Now, your lordship,
7 years you can apply
Millards,
for that.
that is the direct promotion from the bar, Millards, but otherwise from
No.
promotion base. Yes. Yes.
You are not aware of the recent
Suitability.
constitutional decision.
Constitution bench or 3 judges? No, 3 judges said that even for civil judge junior to senior, you can have a suitability test.
For fast track in 3 years.
Yes.
It is 32.
That's
Then
fast track.
again a fast track in 3 years.
Yes.
That is 35. But then we said 7 years total.
Yes.
The lower judiciary and the civil
Yes.
division and also the what do you call the senior division.
Yes.
Then both together 7 years. 29, 35, the 36.
That's I believe 50%.
20 times.
I believe it's 50%, but 50% would possibly be the other age.
And judicial service cadre is not a serious problem.
Yes.
That is at the right age they are taken care. The only issue is of the later
Entry level. And then you add in 1 or 2 years of preparatory work. These exams will not take approximately from what we
That is the
understand.
whole difficulty, senior counsel.
Yes.
When I sat in the constitution bench also, I said, now the source is the coaching centers. I don't mind saying that.
Yes.
It's open court.
By all means.
That is the entire problem. I have been a chief justice. I have been a senior judge in the court. I've gone through interviews. We have seen the direct district judges. It's not, don't say that without any empirical formula. From our experience, we are telling you.
No, that's true. I was only adding to say, it's possible to do it, as we discussed on the last occasion, by other curated measures. For example, MNLU, Maharashtra National Law University, has an honors program in adjudication and litigation. It goes towards justice and specifically towards this program. For example, your Lordship, my learned friend
As a lawyer, you will definitely say that you get more training inside the courts than in classroom.
I'm saying so, but add that. First, you have a course. There should be internships, because my lord only suggested, my lord the Chief Justice, was on the last occasion, have a actual practical experience built into the law schools itself, my lords, which is mandatory. No, this internship, but practice as in practice, my lords, within the period.
After visiting at least 16, 17 top national law schools, these all children, bright children, they will go to corporate entity because of this condition.
Yes.
Yes, Your Lordship.
That's a problem, my lords. And women, my lords,
It should have been imposed in phased manner.
yes.
The first year it should have been 1 year, next then 2 years, then 3 years. That is the way when court creative law is made applicable, that is the past practice is also.
That's right.
We have unfortunately thrusted upon directly. Because of that, there is a lot of hue and cry in the all top law schools.
Yes.
The children are not going to wait for 3 years to waste their time. They are the children who have competed through time to competitive test.
Yes.
A test which is now more vigorous than the NEET or than the medical, and they have got admission as per their merit. If parents have spent a lot of money, now they are not in a position to wait. That is the crisis we are facing.
That is one implement.
As a judge, as a chief justice, and reflecting to matter.
After this,
Taking any stand, my lord.
That's right.
For anyone read it, it was on the social, reading it, my lord. First, affidavits, etc., that your lordships have seen. Now, my lord, para 3. Requirement of 3 years practice at the bar mandated in so and so operates as a condition of eligibility for entry into judicial. 12 high courts have submitted affidavits, etc., that your lordships have seen. Now, my lord, para 3. Requirement of 3 years practice at the bar mandated in so and so operates as a condition of eligibility for entry into judicial service and therefore ought to remain uniform across categories. However, considerations relating to suitability of candidates such as evaluation benchmarks, i.e. cut-off marks, examination modalities, or other aspects of recruitment process may permit calibrated accommodations consistent with the objectives of the Rights of Persons with Disabilities Act and gender inclusion. This would also include providing infrastructural amenities in court complexes, particularly for persons with disabilities. High Court of Jammu Kashmir, your lordships have seen, I am not reading it. My lord, now please come to suggestion 2. Relaxation only for women and persons with disabilities. It is submitted if relaxation in 3 years practice rule is to be granted to any categories of candidates, it should be restricted to women and persons with disabilities. It is submitted that uniformity in eligibility conditions should be retained, as the number of categories who may otherwise claim exemptions and relaxations would be beyond enumeration. While relaxations for age, number of attempts or cut-off marks may be granted, as regards eligibility of years experience at the bar, it is submitted that these two categories may be permitted to complete the requirement of 3 years experience at the bar, either prior to or subsequent to clearing civil judge examination. However, quantum of 3 years may be in terms of so. So I am saying, my lord, your lordships may permit them to take the examination if they.
This condition is slightly impractical.
Very well, my lord. I'll just.
A very good substitute for it.
Anyway, I am reading it here.
We can't send a selected judicial officer to bar.
Yes, Your Lordship.
That is not.
Yes, Your
Very,
Lordship.
very.
What we can do is that in the judicial academy, yes, there can be 6 months
Right.
training only for practice.
Yes, Your Lordship.
May I read para 6? It is submitted that in case such relaxation is granted to women and persons with disabilities, they may allowed to, so this your lordship is saying is not very practical, to sit for civil judge junior division examination as a fresh graduates or as candidates having less than 3 years experience. However, after clearing the examination, they will be mandatory.
That's the best way out.
Yes.
If not in this matter, I will,
Yes.
at least before the meeting office, I will do it.
Right.
All these officers should be attached as law clerks with the sitting judges.
District judge.
District Judge, Your
Correct.
Lordship.
Absolutely.
With all district judges, with all high court judges and in Supreme Court.
Yes, Your Lordship.
That would be the best way to teach them.
That will
That
suffice.
is that is a proposal made also Milords, for the Center for Research.
So that
Lot of training, foundation work.
yes. My lord, that is in fact contained in suggestion 4, but anyway.
Your Lordships, before
Once, then let's be finished. Suggestion 3. All right, very good.
Your Lordships, my junior here, she is an MBA and she comes from Guwahati, Your Lordships. She sat for Guwahati examination in 24, Your Lordships. She couldn't take the mains. Now she came here. Now she's rejected
Just let him finish his suggestion.
because of this.
My lord, I am just placing it so that your lordships may either accept. My lord, now, my lord, so I have read para 6. It is submitted that state bar councils may be directed to facilitate a mechanism for helping such candidates in obtaining requisite experience after clearing civil judge examination. Alternatively, for the said 2 categories alone, women and persons with disabilities, practice period requirement may be reduced from 3 to 2 or any other period as this honorable court finds appropriate. That has come in some of the suggestions. Suggestion 3, my lord, is the staggered implementation in the transition period.
Quickly, I was putting.
So I should have perhaps put that at 1, but I'm sorry, it's at serial 3. Very well, I'm sorry. my lord. While retaining the conditions for recruitment as laid down in All India judges, in the transition period of next 3 years, fresh law graduates may be permitted to appear for civil judge JD examination. Candidates who clear the examination shall undergo the requisite training at State Judicial Academy. After transition period of next 3 years, 3-year experience rule may be made mandatory. That is to say, for 3.
3 and 2
Yes, yes,
should be mixed together.
correct.
That you will not be allowed to hold the court
Yes,
until you undergo all these courses
right, my lord.
and until the district judge or the high court judge with whom they have worked certify that yes, in terms of the
So-
demeanor, conduct, knowledge, practical knowledge, the officer is fit for.
So, my lord, these courses, the State Judicial Academy can obviously specify, or as your lordship said, law clerkship, then my lord, 10. Alternatively, practice period of 3 years prior experience can be 0 years, 1 year and 2 years, respectively for aspirants appearing for the examinations in the next 3 years, respectively. So, this is another aspect of staggering. Both are staggering aspects. Therefore, 3-year practice, thereafter 3-year practice rule may apply uniformly. So, as your lordships, if perhaps suggestion 3 meets with your lordship's approval, is I put in all the other suggestions also, because I had to put in 3-year rule because all the high courts are saying that their experience over the last 23 years is that they want people with some experience. So, my lord, we can't disregard that also, which is why I put that as 1. But this 3 your lordships may see. And 4 is reasonable accommodation, which in any case should follow, my lord. Whatever steps your lordship takes, that there has to be reasonable accommodation for people who are specially able in terms of infrastructure, in terms of accessibility, in terms of perhaps providing them judicial internships, etc. And those are suggestions of 2, my lord, senior and well-known advocates that I put there. In fact,
Can I hand over, Milords, just a small suggestion, Milords? 1-page suggestion within this, Milords, with a small compilation, Milords. I'll only refer to 1 page, Milords. Page 10. I'm not going into, Milords, what the judgment was, Milords, just the suggestions. 4.2, Milords, at page 10. At the bottom of the page, Milords. Post-selection curated training as opposed to license fair practice requirements. Recommended that the practice experience may be incorporated. Page 10. I'm sorry, boss. Para 4.2 at the bottom. It is recommended that the practice experience may be incorporated as part of the training curriculum of selected candidates. So after that, in the same fashion as the training given to selected IAS candidates in Labasna. This practice experience may be structured in the following manner. Selected candidates undergoing training for civil judge may be attached with district for practical training as an apprentice, law clerk, judge in training, whatever your lordship thinks appropriate. In fact, the Center for Research and Planning of the Supreme Court has come out with this report recommending the introduction of LCRAs, that is law clerks, I believe, in district judiciary to further strengthen administration of justice. Selected candidates undergoing training for civil judge may be attached with designated senior counsel, government pleaders, advocate general, standing counsels for a specified period. It is recommended 4.2.2. It is recommended that certain changes may be made during the law degree at the university level, which provides aspirants with special courses and or experience opportunities which renders them eligible for the examination. The first one, optional structured 6-month practice experience modules during the 3-year/5-year law course. At present, for example, for the 5-year course, it is 5 months as it stands without specification. The second, special degree courses designed for aspirants at the college level itself to identify, train and expose aspirants to high quality training. I was referring to the MNLU course, which is a course BA LLB honors course for adjudication and judging, as it's called. And that's, I think, possibly a very popular approach, because to hone the skills as a judge is possibly slightly different from honing the skills as a counsel. We take far more liberties, your lordships take far lesser. So to that extent, and that is the reason, if experience as a judge is what is sought, then possibly the courses at the initial stages also would be extremely helpful. And we've been encouraging, we want the younger people to go in. Law exams itself takes almost a year or two for applying, for preparing. Secondly, more than one attempt. It is not a single attempt. It's like the AOR examination. You don't get it on the first attempt necessarily. It goes for 1, 2, 3, whatever the attempts might be. So, all that period has to be taken into account for purposes of going down the career ladder. So those obstacles, particularly made more vulnerable for women, is something that has to be done away with, and that too, mid-level. The Constitution mentions these judgments, ultimately we come out, where people have been waiting for the last 3 years, having tried, not succeeded, or otherwise preparing, not gone in, or possibly not having enough money, going in for coaching, as your lordship said, correct. You're all going for coaching in every direction today, even at the school level, leave aside at a higher level, be that as it may, not in our times, but that's not the story. So, coming to that, they've been waiting for the last 2-3 years, suddenly to make it midstream and say now you are either out or you're not eligible, and to put themselves at not, is something that cannot be done. Finally, just one last word, the students, the graduates, have not been taken into account. What has been taken into account in this entire exercise is only, the high courts, and now, the NLUs and other universities, some universities, they've advocated. What about, management universities, people who are actually involved? Let us, some retired judge, be put in, control of the situation to see and assess, not control, I beg your pardon, assess the situation and take all the stakeholders to some extent. In the meantime, this requires a thing. It cannot be done like this at one level. And if at all, Bihar exam is on the corner. They come in different, there's no certainty for exams. Every state has its own exams allocated at whatever time. So you don't even know, what would be ultimately hitting people. They can't just be waiting in the air, to what will happen. So for the time being, these are not annual examinations. So your lordships, it happens once in 3 years, Therefore, your lordship has to take into account for the time being, to stay this while your lordship considers, the modalities which might be set in, something must be done. Understood, However, what should be done? And within the period, after selection. My insistence, is twofold. During the law university stages and, during the period after selection, which can be whether by way of internship, whether by way of, training, whether by way of putting in programs anywhere, that is another matter altogether.
Your lordship.
15 dispensation is required for women, your lordships, for 3 reasons. One, your lordships, is as far as women is concerned, for them, along with their domestic responsibilities, your lordships, for them, when they can take an exam is also not determined. They can take an exam depending on whether at that point of time they are getting married, they are having children and so on. So therefore, the bar acts as something which takes away that entire career opportunity, your lordships. And like your lordships, secondly put it, your lordships, then they go in different professions whatsoever, and we lose very good and very intelligent people, your lordships, because there's no certainty in this entering the career. So at that entry point, your lordships, when the barrier is there, that is the difficulty which all these girls face, your lordships. Going forward, your lordships, they will definitely be shoulder to shoulder with everyone else. They'll do their suitability tests, their career progression, they will appear for all the examinations. There is no difficulty, your lordships. At the entry level itself, when they are put back, your lordships, and that is the crucial time for their lordships, we all have experienced it. That is the time when we are all thinking of setting up families and putting them together, your lordships. If we are set back another 3 years, then your lordships will never be able to move forward in our career. That is facially this appears to be neutral, but substantively it hits us, your lordships. It hits us very, very badly because none of the young girls, your lordships, are able to, once there is a break, then the family always insists that, all right, now move on to something else. Right after graduating, your lordships, they are taking these exams, they are in that same streamline, your lordships, they can hold back. They can tell their families that this is not the time for me to move on to the other areas, your lordships. So that is a very turbulent time for young girls, your lordships, and that has to be kept in mind, your lordships, because this barrier is what is hurting us. And I would definitely say that Dr. Faizan Mustafa's suggestions, your lordships, with regard to training, because lordships always has moved towards inclusivity. So whatever allows people to come in is what lordships wants. The larger the pool, the better the talent we will get, your lordships. So let them compete. It's not, as my learned friend said, it's not as if they are succeeding in the first year itself. They'll also take a couple of years to succeed. There'll be interview, there'll be written tests. So their suitability and excellence is anyway being tested, your lordships. So our respectful submission to your lordships is that for us, the reproductive age is very, very crucial. And that should not be set back because of this professional problem.
Just today, Your Lordship, Honored friends, Milords, at the entry level, Milords, it's the highest for women, Milords. It's a very high level. In fact, it is later retention, which becomes difficult, or escalation, Milords. But at the entry level, the number of women, Milords, in the profession is becoming one of the largest.
Your lordships, your lordships, the
How there are girls.
That's right.
in same law.
And it goes down, Milords, as we go ahead. We don't want to give the figures, Milords. Everybody knows them.
What is he wants also?
Yes.
Your lordships, the submission that we had made it on the last occasion also, that people with disabilities face three kind of barriers. One is the no seniors hire persons with disabilities. One, if we even come up to the 1 year or a 6 month practice period. Second is no client relies on a person with disability and advocate. Third is the structural, infrastructural, and the digital accessibility. Even I would like to quote, your lordships, there was a report by the State of Judiciary report by the Center of Planning and Research by the Supreme Court itself, which says that more than 85% of district court are still not accessible for persons with disabilities. So this is a very important point which needs to be addressed by your lordships. Again, another thing, your lordships, the judgment that we were quoting of the 3rd of March 2025, your lordships, in that there was a judgment regarding an appeal which is titled as Ayush Shardi versus the High Court of Madhya Pradesh. There are certain paragraphs, which I quote in paragraph 33 to 41, what the division bench of the Honorable Supreme Court has quoted, the views, how it indirectly discriminates people with disabilities, how it also discriminates people with disabilities on the ground of equality doctrine, your lordships. And again, the reasonable accommodation. So the reasonable accommodation principle comes there only. It plays the roles there, your lordships. So we are not against the practice. We are saying, your lordships, we are also submitting that we only just want the relaxation in the form that we don't have to run here and there. We just are seeking an accommodation, a reasonable accommodation in form where either we are given an opportunity to, in the law schools, whether it's a 1 year additional to the 3 years, no issues in that, or the training, which is, your lordships, 1 year, can be extended to 2 years. And through that, the young generation lawyers can be placed with the legal aid, which can strengthen our legal aid system also, your lordship. That's a suggestion from our end. And your lordships, we also have compiled a report and submitted before your lordships an additional through an additional affidavit, which was a research kind of we have conducted before after your lordships passed the directions to the NLUs and the high courts on the 15th of January 2026, your lordships. So we conducted two kind of researches. One is with the law students and another is with the law graduates and the enrolled advocates, recent ones. So the highlighting part into that, most of the part of the, whether it's a person with a disability or without disability, everyone is saying this 3 years will anyhow has to be modified or has to be revoked, or it could be in the form of a kind of a mandatory internship or a mandatory law researcher with the attachment in any of the courts, which could suffice and have or give the experience to that law judicial officer, which has to deliver the justice at the end. So, Lordship, those are the submissions from our end. Another thing, Your Lordships, at just the last point, we have also moved into IEA, Your Lordships. The number is 45820 regarding the Bihar Judicial Services, which has been recently notified, Your Lordships. So we are just seeking, Your Lordships, if Your Lordships appreciate that suggestion, Your Lordships, we are just seeking. This is 18th of March, Your Lordships. So our suggestion is all the candidates, irrespective of the 3 years practice.
Time being, who is representing Bihar High Court, Patna High Court?
Your Lordship, the suggestion, Your Lordship, the suggestion is just that the candidates might be allowed, Your Lordships, provisionally.
Instead of
Before we decide, Your Lordships.
creating more complication, we can ask the High Courts and State Police Risk Commission to extend this.
Yes, Your Lordship.
Meanwhile, we can.
Or the extension can be done, Your Lordship, before Your Lordships decide, or something, a modulation could be there, Your Lordships, which does not impact the young generation, Your Lordships.
Yes, what is it, Your Lordship?
This is the notification, my lords, if your lordship wishes.
What is he saying here?
Already come up with an amendment. It's about to come out with an amendment. The Lordship, so all
Your
the.
lordship will have to pass some order, my lords, staying this process, my lords, for the time being. There's no, my lords, other way. Otherwise, there are different dates, my lords.
On 9th of February 26, Delhi High Court has amended its rules.
Yes.
You say what?
So I'm in 301.1.
So Lordship, for Bihar, it is 18th of March in the last date.
Plus the notification is before your lordship, lords. Just hand over first.
Mamlu representing Bihar State, Your Lordship.
They want-
Knowledge that may arise, say, since we are seized of the
Right.
matter re. Issues arising out of description of 3 years practice as a precondition. To extend the date of, last date of submission of application, comma, if they have already advertised the post, comma, up to 30th April 2026. Up to 30th April 2026. The fresh advertisement that will be issued by any state stroke high court or the state police commission will also have a cutoff date, 30th April 2026.
Lordship, for judicial magistrate, it is mostly done by the. I'm in.
We said both. We said both.
Yes, Lordship has.
Yes, high court or the police.
Yes.
My lords, you've handed over the Bihar notification if your lordship wants to, please have.
Now it has to be extended.
Yeah, Your Lordship, just one small submission.
Keep the train.
Mine is
336099.
So
I'm in 301.1.
IA filed by me for modification and implement. Here concern is acquiring higher qualification. I am LLM student. I'm just passing out now. And
This is separate
issue.
No, Lordship, with all due respect, it is interlinked. So far as Indian Law Institute, National Law University, Delhi, Rohtak, and many other universities
has already
just a minute, sir. Just
already approached the High Court.
I approached the High Court. High Court declined to interfere because of the judgment given by this honorable court, and we were asked to make a passing out now. And
This is separate
issue.
no, Lordship, with all due respect.
Young man
Yes, sir.
extended the date to
Very erudite kind of presentation.
pointed out the young man
Yes, sir.
that the advertisement is there, and then we can understand that urgency was there. Now we extended the date to 30th April.
Yes.
That's not that.
Yes.
So we will, we are also examining, you are also in the right field. Ultimately, this, let's be very clear, the practice condition will have to be there. This is the view taken by a bench, and we should respect that bench. The only issue is the modalities of giving effect to that, number one. Practical difficulties which are right now have a reason or being experienced, how to wriggle out of those, and how smoothly infuse this practical experience into the system, which is for a better qualitative judiciary, which is a very essential component. So that has to be there. So, for example, we were just saying that maybe a clerkship with a High Court judge, with a Supreme Court judge, is qualitatively better than maybe or may not be. But there's a different perception. Huh? From our side, we might think it's better than practice. From your side, you might think that no practical experience. So these are all aspects we will also consider, you also consider. 3 years should be there, but is it?
It should be structured.
That only as an enrolled an advocate sitting idle in one court or the other and watching the proceeding, will it going to make them eligible, or a platform like
A structured one.
make them free legal aid counsel? That's a good idea.
Yes.
That's a very good idea. That you 3-year practice means that they have learned something.
Yes.
Not that they have rest of the other wonderful things they have learned, and other than the
The third point, my lord, I want to make is
Because also after selection, my lord, ultimately your lordship will have to consider that.
We'll circulate one.
the other third point I want to make, my lord, is that it's set out in many of the presentations, the massive expansion of judicial academies and judicial trainings in the country, which, my lord, the impugned order doesn't take note of. Now, my lord, across the world, Japan, Germany, and elsewhere, France, the trend is away from practice at the bar and towards very in-depth, very intensive training. And my lord, there are documents on that we want to show your lordship. That is the way to go in terms of training.
we earnestly wish that our judicial officers, high courts and Supreme Court have the same quantity of work as in Japan or in Germany or in other countries.
More than that,
You can also have the luxury of so many things.
That parity is missing. That parity is missing, because I don't think the nature
The
can be
point I'm
compared.
trying to make, my lord, is that training of judicial officers post-joining is the way to go for India. And I'll show your lordship report after report. Yes.
Understand the value of post joining.
Yes, my lord.
Capture best of the talent.
Yes, my lord.
It's something like that. You pick up best of the talent, keep it in your kitty, and then you put them training. That is one way.
Yes.
There is that for 3 years you abandon them. That unless you go there practice, I am not going to consider you. And
Yes.
in 3 years, no simple.
Yes.
Also the certification process, it's by anybody.
These are the two both institutional interest is the paramount consideration. Nothing
And
else.
it'll be, my lord, interesting to see how many NLUI graduates actually, after the 3-year rule is in, implemented, how many of them abandoned litigation completely? Quite a considerable number. The statistics are there. I want to check. Quite of them abandoned. So you're losing the best brains coming out of NLUI. NLUI, quite a considerable number. The statistics are there. I want to check. Quite of them abandoned. So you're losing the best brains coming out of NLUI. NLUI was made for that, to make the judiciary rich with. They're dropping out of the system.
Even in our years, those who stayed back took the hard way, became very good lawyers, excellent lawyers.
Some, my lord, some.
Many of them,
When you look
many
at-
of them,
my lord,
some
when
of
you
them
look
came
at-
to the bench also.
When you look at, my lord, SC/ST people, they fall out of the system completely.
It is completely out
They
of
train to come into the judiciary and they fall
not in
out
this
of the.
context at all. Yes. That is a different thing for the training. Many of the legal service authorities across the country. In Kerala, I know that there is training conducted specifically for scheduled rights, and now people have come into the judiciary.
But the figures, my lord, are very, very low.
They'll rise. We have had reservations
It's
for
hardly,
so
my
long,
lord,
as the figures improved considerably in the 75 years. So that it will take time.
Well, may I say something? Well, I appear for the Allahabad High Court. While a suggestion has come through that it should be post-appointment that this training takes place, which means 3 years post-appointment. So a person who's being appointed today will start working only 3 years later. So my only concern. My only concern is, my lord, as the High Court, that it may lead to a vacuum where we may not have enough officers in civil judge. Junior division, this has happened in the past in UP. My lord, we had a.
This will happen today. And today what will happen? If you don't become the meritorious people,
Yes.
not in default, what kind of officers you will have then? They will have a liability for 30 years, 40.
I agree, that's all.